5 seconds to go. Start. Subsection 5 of section 149, which imposes a liability on the insurer, must also be given its full effect. The insurance company may not be liable to satisfy the decree, and therefore its liability may be zero, but it does not mean that it did not have initial liability at all. Thus, if the insurance company is made liable to pay any amount, it can recover the entire amount paid to the third party on behalf of the assured. If this interpretation is not given to the beneficent provisions of the Act, having regard to its purport and object, we fail to see a situation where beneficent provisions can be given effect to. Subsection 7 of section 149 of the Act, to which pointed attention of the court has been drawn by the learned counsel for the petitioner, which is in negative language, may now be noticed. The said provision must be read with subsection 1 thereof, the right to avoid liability in terms of subsection 2 of section 149 is restricted, as has been discussed herein before. It is one thing to say that the insurance companies are entitled to raise a defense, but it is another thing to say that despite the fact that its defense has been accepted, having regard to the facts and circumstances of the case, the tribunal has power to direct them to satisfy the decree at the first instance and then direct recovery of the same from the owner. These two matters stand apart and require contextual reading. We may fruitfully note that the three-judge bench adverted to situations where the driver does not have a license and the same has been allowed to be driven by the owner of the vehicle. By such person, the insurer would be entitled to succeed in defense and avoid liability, but the position would be different where the disputed question of fact arises as to whether the driver had a valid license and where the owner of the vehicle committed a breach of the terms of the contract of insurance, as also the provisions of the Act, by consciously allowing any person to drive a vehicle who did not have a valid driving license. The Act did not allow a person to concisely drive a vehicle under Act. This must be noted here. The court held that if on facts it is found that the accident was caused solely because of some other unforeseen or intervening causes like mechanical failures and similar other causes having no nexus with the driver not possessing the requisite type of license, the insurer will not be allowed to avoid its liability merely for technical breach of conditions concerning driving license. That apart, minor and inconsequential deviations with regard to licensing conditions would not constitute sufficient ground to deny the benefit of coverage of insurance to third parties. The other category of cases that the court addressed to included cases where the license of the driver is found to be fake. In this context, the court expressed its general agreement with United India Insurance Company Limited versus Lehru and stated that in a Lehru case, the matter has been considered in some detail. We are in general agreement with the approach of the bench, but we intend to point out that the observations made therein must be understood to have been made in the light of the requirements of the law in terms whereof the insurer is to establish willful breach on the part of the insured and not for the purpose of its disentitlement from raising any defense or for the owners to be absolved from any liability whatsoever. The three-judge bench summed up its conclusions, and we think it appropriate to reproduce the relevant part of the same. The breach of policy condition, that is disqualification of the driver or invalid driving license of the driver as contained in subsection 2 of section 149 has to be proved to have been committed by the insured for avoiding liability by the insurer. Mere absence, fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third parties. To avoid its liability towards the insured, the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of vehicles by a duly licensed driver or one who was not disqualified to drive at the relevant time, even where the insurer is able to prove breach on the part of the insured concerning the policy condition regarding hold of a valid license by the driver or his qualification to drive during the relevant period, the insurer would not be allowed to avoid its liability towards the insured unless the said breach is because of the driving license. Stop.